alternative to avoid the wheel stops and whether the condition met applicable safety standards. So in this case, each one of these conditions is satisfied. First, as I've shown you in the photograph, the wheel stops were clearly marked. They were a light color in contrast with the parking lot itself, easily visible, even by a plaintiff's own admission. The wheel stops are the proper height. There's been an assertion that the wheel stops needed to be no higher than 6.5 inches. The wheel stop in this case was 5.5 inches. There have been no prior complaints. There have been no prior injuries. There's nothing to put our calling on notice that this wheel stop or this parking lot could be unreasonably dangerous. There was a reasonable way for the plaintiff to avoid the wheel stops. I'll share my screen again. This is the exhibit to her deposition. The blue line represents the direction that Ms. Yates pulled into the parking lot and drove all the way around. She parked, she knows she didn't park in either of the end spots, which is why there's an X on those. So she parked somewhere in the middle here. The court can clearly see that there is a pathway between all of the cars. And, excuse me, I just lost my train of thought again. Excuse me. The plaintiff, if she had been worried about her safety, she could have walked around this way into the building or around this way into the building. Instead, she chose to walk in and among the cars, which is fine because that's the reason the wheel stops were designed to be the length that they were made and positioned where they were in each of the parking stalls was to create a pathway for pedestrians to get from their car to the building. The parking, as I said before and showed before, the parking lot also met the City of Dallas's safety standards. So it's met all 7 of the factors that are set forth by the 14th Court of Appeals. And the only reason I rely on that is because it's a nice succinct list, and the list is derived from other cases, appellate court cases that have been decided in Texas. So these parking wheel stops are not unreasonably dangerous. Even if they are, our calling did not owe plaintiff a duty to warn or remedy.
I got it. Let me hear from Mr. Delhomme. That's okay. Let me hear from Ms. Delhomme.
Yes, Your Honor. We have a basic problem with the fact that the defendant is asking you to declare something not unreasonably dangerous at law. And there are several things that the Supreme Court has made that declaration about. Wheel stops are not one of them. And I think there is all the different areas that the defendant has addressed have just demonstrated to the court several genuine issues of material fact. We say our client the plaintiff was an invitee. She was there, open to the public, meeting one of their clients to further their mission of helping a homeless person or a needy person receive services. So we think she's clearly an invitee. And also there is a genuine issue of material fact as to which expert or which regulations are going to be applied to these wheel stops. Their expert referred to the regulations that we cited in our brief. And he was of the feeling that they don't apply. Well, that's a genuine issue of material fact. Do they apply to the City of Dallas or don't they? Also,
I think Ms. Mossman said that you guys didn't attach anything from your expert.
No, we did not. That's correct, Your Honor. There were no attachments that I'm aware of to our response.
There are no
However,
attachments to your response?
I'm sorry.
There's no attachments to your response?
I may be incorrect, but I didn't see any, Your Honor, when I pulled it, but I could be wrong. They were cited within the brief itself, and they were mentioned in defendant's expert report.
What is mentioned?
Those standards, the ASTM, which is American Society of Testing and Materials. There are several different standards that in fact, we did set them out, and all the different requirements they have for wheel stops, as far as how high they should be, how wide they should be, whether they should be painted, whether you should even use them at all. Because I also argue that we're not saying that the plaintiff did not see any wheel stops. That's not the problem. It's just that when you're walking between cars, or you're walking where you didn't park, she didn't see the one that caused her injuries. So
I guess my concern here is just, you generally have to bring up a genuine issue material fact, and if you didn't attach anything, any affidavits or depositions or anything to the summary judgment response, and I'll be honest, I couldn't find the summary judgment response, and Odyssey is down today, so I guess there was one filed, but there were no attachments to it.
If you let me to, I'll look and make sure that I'm not speaking incorrectly.
Ms. Mossman, were there attachments to their summary judgment?
No, Your Honor.
Okay.
Your Honor, I apologize for not knowing off the top of my head. I didn't prepare this response, so I didn't want to speak out of turn and say there weren't, because I didn't see any attached to this response.
So how are you relying on their evidence, I guess, saying that?
Yes, Your Honor. I mean, there's a lot of genuine issues of material fact in this matter, from their arguments and from the evidence presented at the deposition. It's just repetitive to just attach the same exact documents and say, we have a genuine issue of material fact. This is the genuine issues we have with what they've presented.
Okay. Ms. Mossman, what are your thoughts on
To the extent they want to rely on defendants' evidence, then summary judgment must be granted, because we've proved up all of our evidence. We have the plat and the photographs and our expert's report. All of it is authenticated. All of it's proved up. Our expert does not cite the same standards as plaintiff's expert. And the only reason that they're even mentioned in his report is to distinguish and explain why they don't apply. So that's, plaintiff's counsel is incorrect that we rely on the same standards. Our expert says explicitly these standards don't apply. They were not adopted by the city of Dallas at the time of this incident, and they haven't been adopted since. So it's just literally, and our expert says this, that this is just plaintiff's expert found some standards that supported his preformed opinion and has no applicability.
Did you attach, Ms. Mossman, the plaintiff's expert report or plaintiff's expert testimony?
No, sir.
I guess, Ms. Delhome, yeah, this is not the way this is normally done. And so can you share screen where within their response that there's evidence that supports your response to summary judgment?
I'm confused. Are you asking me to show you where and there?
Yeah, right. Share screen. My case management system is down. It's down for the whole county right now. So if you could, I read this last night. I didn't even see a response, and so, but apparently there was one filed with no attachment. So, you know, you say that there's a genuine issue of material fact in what they submitted. I didn't see that when I read it, but I may have missed it. So if you could show me, you know, you say that they've raised a genuine issue of material fact for you, for your client. If you could show that on the screen, what, you know, through share screen, what exactly they've said that supports your argument.
Well, Your Honor, I think what I'm saying is that on almost every issue that they are bringing up, we disagree, and we have shown through the deposition, through the discovery, that our client, that we disagree with that there are genuine issues of material fact as to whether she was an invitee or not. She testified that she was going there to meet one of their clients.
Okay, so, and that's in the deposition, I guess. So that's what I'm trying to get at is if you could share screen and what exactly, so you say that the deposition that they attach supports the position that you're an invitee.
I think it does, yes.
Okay.
Because she said she was going there to meet one of their clients, and she had talked to one of their case managers about it.
Is that in your attachments, Ms. Mossman?
No, sir. And the nowhere in any of the evidence, even if we had attached the entire deposition of Miss Aids, which we didn't, we only attached the portions that we're relying on. There's zero evidence that her client was also a client of our calling. There's no client relationship between our calling and this. And anyway, there's no evidence of that. They made it up to kind of leapfrog past the obstacle that they have in showing that their client was an invitee. I went ahead for purposes of efficiency here today, and just for purposes of my argument, assumed that she's an invitee because she's still, summary judgment is still appropriate, but there's no evidence that she was an invitee. There's no evidence that she was there as to help for the mutual benefit of our calling. She was there for her client only. And there's zero evidence that her client was our calling's client.
I'm looking at the deposition because I just read where they were asking her, she talked to the case manager at our calling, and she said she talked to her on the phone. No.
So Mr. Hum, obviously we have to go based on what the evidence is before the court. So can you share screen whatever you're referring to that says?
Yes, I'm trying to find it, Your Honor.
Ms. Knight, what are you here for?
I'm here for the motion to compel and Brittany Lighthizer versus SHF Icon LLC doing business as the Icon at Ross Apartments and Simpson Property Group LP.
Okay.
Let's see. Okay, let's see. It looks like it's on page 28. I think it's their exhibit B. Did y'all lose me? Am I going?
Yeah, go ahead. You need to share screen that, please.
Okay, Your Honor, I'm going to have to transfer it over to this computer. I'm looking at it on another device. I don't think it's going to share screen.
If you'll tell me
I'm trying to tell you, yeah, it's page 20. It's a deposition exhibit. I don't want to call it the wrong. If it's A or B, I'm not sure. It's page 28. And you're asking why she was there, and you ask her why she met her there, and she says you asked about Jenny Hill's case manager. That's on page 30, line 3.
Can you
And she
share that,
says-
Ms. Mossman?
Yes, Your Honor.
No, and it goes down to line 10 on page 30, where she says, I'd spoken with her on the phone. And then you asked her about the employment agreement, and she said she didn't know about our Collins employment agreement.
Okay, here we go. So it starts down here. This is page 28. So you were at our calling because you were visiting your client, Jenny Hill, correct? Yes. Did you have I guess I'm trying to figure out why you met her at our calling as opposed to someplace else. She said that was the agreed upon meeting place because she went there for services, was my understanding. So she's not even sure why her client is at our calling. And when you say that was the agreed upon place, the agreement between you and her, yes. And she says, and her caseworker, I guess. And I said, let's see here. When you were at our calling, did you meet with any of our calling staff? And she said, I met with her case manager. That may not be the correct title, but her case manager and I met after I fell. So she wasn't necessarily trying to meet her ahead of time. I'm not sure that let me get back to because I have it more succinctly in here in my PowerPoint.
I think that's a fact issue as to whether or not she's an invitee. So,
Okay.
So where in the transcript does it raise an issue as to this being a danger, or where in the evidence does it say that this is a reasonably dangerous condition?
In the evidence? The only evidence, or the only thing I can present to you, Your Honor, that says it's an unreasonably dangerous condition, or the American Society of Testing and Material Standards that are contained within our response. They are on page 5. Let's see, they begin on page 5, I think. Page 5, continuing page 6.
Can you share screen that, please? Ms. Mossman?
Oh, yes, sorry.
I'm sorry, you were, can share, I probably can share screen now. Let me see. Let me see. Just a second.
So this start here, and there was, in her response, plaintiff cites these standards, but they're taken out of context. They would require expert opinion to show how these standards apply to the facts of this case, which
I guess my question is, the plaintiff has an expert that they've hired on this issue, is that right?
Yes, Your Honor.
Why isn't there a affidavit from the expert on this attached?
I guess the best thing I can do, Your Honor, is ask for a continuance to attach it because I don't have the answer to that. I'm of counsel and I was just asked to argue this motion this morning, and I am not, I can get that, I'm sure. If it exists, I can get it and get it to you. Baby lawyer probably drafted this, Your Honor, and I'm not sure if she was aware that she needed to attach that. If you will give me a continuance to get that evidence, I'd be glad to produce it or concede that we don't have it, either way.
What are your thoughts about that, Ms. Mossman?
Defendant objects to a continuance in this case. First, the continuance had to have been filed by the time that the response was due, which was 7 days ago. It must be in writing. And so a verbal motion for continuance is invalid and the court can't act on it. This motion has been set for hearing. If you count the first time we set it for hearing, this has been on the court's docket and presumably on plaintiff's counsel's to-do list for months. I mean, it's been at least 2 or 3 months that this has been an issue. So scrambling at the last minute to provide key evidence that plaintiff knew from the get-go months ago she was going to need would be inappropriate, unfair, and not supported by any procedural rule or case law that I'm aware of.
Still home.
Yes, Your Honor, the attorney who did prepare this is no longer with Castle Law. She hasn't been there for like I think since the end of January. So what was on the things to do list, I can't address, but I can tell you that, you know, I have just been assigned to this case this morning, and I'm trying to make an argument based on what I have in front of me. And I'm like, there is an expert and an affidavit could be attached to this. If we continue the hearing, I can get that information and get it attached.
And I apologize, as I mentioned earlier, my case management program is down. Is this the only defendant in the case?
Yes.
Yes.
And to address plaintiff's counsel's representation to the court, this response was drafted by Ms. Castle herself. She's the named, lead partner. So it was not drafted by a low-level associate who was no longer with the firm.
How do you know that?
It's signed by Ms. Castle, the responses.
And
Okay.
Samantha is the one I'm referring to, Your Honor. She's right under Ms. Castle, Samantha Johnson. She's no longer with the firm.
It has Ms. Castle's signature.
When is this case set for trial?
March 29th, 28th, 29th,
Of
29th.
this year? Ms. Delhome, they put you in a tough spot here, I have to say. I mean,
I'm doing the best I
and
can.
I don't disagree with Ms. Mossman at all. I think, you're, I mean, this could have been dealt with fairly easily just by having the expert attach an affidavit that details all of this. And I understand. I mean, I will say, Ms. Mossman, that I've had this situation come up before, and typically what I'll do is, if there's a continuance filed, I'll grant it, although this is really close to the trial setting. If they file a motion for new trial with the proper basis, there's a good chance if it's done correctly, then I would grant it. But I understand if you want to kind of,
Well, I apologize.
Go ahead.
So, you know, we kind of got hung up on the unreasonably dangerous element, and there is no expert testimony. So let's set the expert testimony and the failure to attach proper evidence aside. Plaintiff has no evidence that our calling knew or should have known, because the parking lot and the wheel stops passed the city of Dallas's own standards, and our calling did not.
And I get what you're saying there. I've dealt with this issue many times. I used to do plaintiff's work in personal injury, and you know, I get all that. I will just tell you how I typically handle these is if there's an expert report that addresses all of these issues, or an expert affidavit that attaches all of these issues, assuming that it's properly done, to me, that's usually enough to defeat a summary judgment. You know, what will the jury do at trial is a different issue. But so what I guess I'm saying, Ms. Mossman, is that I'll grant the summary judgment, but I want you to know that if they do it correctly and file a motion for new trial timely, there is a chance that I would reconsider that. I don't really like getting these types of cases dismissed because of a mistake, basically what it sounds like. And so I'll understand completely if you say, Judge, we want to grant the summary judgment and just, you know, see what happens. It might mess up your trial setting if you're really eager to go to trial in March, because if they grant a new trial, you see with the timing, if that makes sense. And so I've been in this situation before where the defense lawyer is like, Judge, we know you, we know that you're going to give them a chance because, you know, you want to be fair to everybody. And so we're going to just drop the summary judgment. But I've also had attorneys in your situation go, Judge, we want to see what happens, see if they actually do what they're supposed to do, and kind of, you know, take a harder line. So, you know, but if you take a harder line, I'm just saying that if they do it correctly, there's a chance that we'll reinstate the case, and then you may mess up your trial setting because of the timing of all of it. Does that make sense?
Sure. And so if you do reinstate the case,
grant a new trial, not reinstate, grant a new trial. If it's properly filed with the proper evidence and all that stuff.
Gotcha. But would we get a new scheduling order? Like, will the deadlines reopen?
I mean, I would probably in that situation leave it up to you, because you're, you know, you didn't do anything wrong here. You did everything exactly correctly. You know, the associate apparently here at Ms. Castle's office, for whatever reason, didn't do this, in my opinion, correctly. And so I would probably kind of leave that up to you. If you needed additional discovery, we would give you that opportunity. Or if you didn't want additional discovery, I mean, I would kind of err on the side of you're the innocent person here, you know, in all likelihood. So I don't know the whole history of everything, but that's just generally how I do it. I don't know if that answers your question, but I would reset it for trial in all likelihood, given the timing, because even if they file a motion for new trial within the next 30 days, this case is less than 30 days away.
Well, unless Your Honor is hiring, I would have to request that the court go ahead and grant.
Oh, you said that you might get fired if you agree to the other. Okay.
I think I would lose a client if I said, no, please don't grant the summary judgment.
Yeah, that I prepared and billed you for it and won because they didn't do it correctly.
Exactly.
All right, Ms. Delhome, I think she's right. I don't blame her for it. So we'll go ahead and grant the summary judgment. But you do tell your client that there is a chance that if they do it correctly and all of the evidence done, I may grant a new trial on this. It's just I want to be 100% upfront. I've seen this dynamic before, and so that's what I've done in the past, and I try to be consistent. So if they don't do it correctly again, then I'm obviously not going to do it. I'm just saying this is something that could be fixed.
I appreciate your fairness, Your Honor.
So, all right, Ms. Monsman, did you submit? I apologize, I can't get anything right now, so I'm shooting a little blind. Did you already submit an order on this?
Yes. We've submitted a final judgment, yeah.
Do you mind just changing it up slightly and just saying that the hearing at the beginning was held on February 28th, 2022, and then go ahead and forward that order, just the, summary judgments granted order, share it with Ms. Delhome, and then email my court coordinator and e-file it as well.
I knew I
anything
should have
else?
gone to Mardi Gras this year.
What did you say?
I got my little Mardi Gras shirt on.
Oh, how fun! How fun!
I should have gone. I've been getting texts all day yesterday at all the big parades this weekend. It's
Oh, how
fantastic.
fun! Well, have a good time out there. You going to New Orleans?
No, it's too late. I have to
Oh.
go on Friday, or it's not really worth it.
Well, have fun. Have fun. All right. Well, great to see you guys. Just get me an order and we'll go from there. Okay.
Okay, thank you,
Yep.
Your Honor.
Thank you, guys. Miss Knight, Miss Hamida, are you guys both here for the motion to compel?
Yes, sir.
I leave. Okay, good luck.
And Mr. White? Are you there, Mr. White?
I am, Your Honor.
Okay. Are you here for the motion to compel as well?
No, I'm here for the next motion, which is the motion to seal.
Okay.
Yeah, Judge, I need one quick second. I had to reboot my computer.
Yeah, that's no problem. Well, we got a little bit of exciting news at the courthouse. Judge Moore has lifted the mask mandate at the courthouse. And so you don't have to wear a mask when you come in.
Well, that's different.
Yeah, it's exciting, kind of exciting. I didn't think that would ever happen. I thought that was going to be we were going to have a mask mandate for my entire time as a judge, but it's,
I know.
for those of you who don't go to the courthouse too much, it's not a big deal, but having to wear a mask all day is no fun.
Especially during the trials that last couple of days and
Oh, yeah.
keeping it on while you're
And that doesn't
talking.
mean that individual judges won't require it, but at least it's not mandated. So,
Okay.
all right. Do you guys want to, do we have everyone here we need to? Are you covering for defend for Mr. Clays or Miss Clays, Miss Knight?
I am, Your Honor.
Okay. All right, let's go on the record on DC 21-11380.
I'm still, just
Oh,
second,
you
Judge.
still- That's okay, sorry.
I'm sorry.
Actually, why don't you guys give me just 1 second? I need to take a very quick break. Tony, is it working now?
Yes, Judge.
All right. Let's go on the record then on cause number DC 21-11380, Light Heiser versus SHFI Icon LLC. Council, make your appearances.
Tonight for the defendants.
Rizwan Hamida here on behalf of the plaintiff.
Let's proceed.
This motion has been filed to compel executed authorizations from plaintiff. The facts in this case are pretty straightforward. From May 2018 until September 2019, plaintiff was a tenant of property owned and managed by defendants. On September 20th, 2019, plaintiff allegedly found mold in her unit. As a result of the exposure, plaintiff claims she has suffered a variety of health problems and financial losses. And on August 23rd, 2021, plaintiff filed suit against defendants for violations of the DTPA, breach of contract, and acts of negligence. Plaintiff is seeking monetary relief of over $1 million in past and future damages for medical expenses, pain and suffering, physical impairment, loss of earnings, loss of household services, mental anguish, disfigurement and disability, out-of-pocket expenses, loss of use, loss of the benefit of the bargain, cost of repairs, consulting fees, temporary housing expenses, lost earnings, lost earning capacity, exemplary damages, and attorney's fees. Defendants have asked plaintiff to execute authorizations to obtain her medical, Social Security, tax returns, and employment records. Plaintiff has refused to provide the executed authorization. Given her alleged injuries and claimed damages, plaintiff has placed her medical history, financial history, and employment history at issue in this case. Because plaintiff has placed these matters at issue, the requested authorizations are relevant. And based on the foregoing, we ask that the court grant this motion and order plaintiff to provide defendant with the executed authorizations within 10 days of the order.
Response?
Yes, Your Honor. We have produced over 600 pages of medical records and documents responsive to their request. Actually, 640 pages to be exact. Texas Rules of Civil Procedure 194.2J states that either, so the requester can request that the injured party produce all relevant records when bills, or in lieu of furnish an authorization. They put both on their request. We furnished all the medical records, all related documents responsive to these requests. We are arguing that these authorizations are overly broad. They are the very definition of a fishing expedition. They don't actually, I don't think any of them have an expiration date on them. They're not limited in time and scope. They just have blanks where the dates are supposed to be. And if anything, they're an invasion of her privacy.
So they're asking for a medical authorization. So let me tell you, I have a very standard way I deal with this on pretty much every case, although this case is a little bit different because it's not a typical personal injury case, back and neck, car wreck case or whatever. So what I typically do is allow medical for the 5 years prior to the accident and anything post-accident to the same areas of the body. I know in a mold case, it's going to be a little bit complicated because the condition can be fairly broad. It can be, respiratory, but also can be other issues. Are you claiming just respiratory injuries in this case or broader than that?
We are claiming broader than that. We're claiming that it did affect her brain, her memory. So we have produced all of the records in response to what happened to her after
Right.
living in. And they're actually asking for authorizations for, you're correct, medical records, also Social Security administrative records.
Let's break these down.
Okay.
So For medicals, so you're claiming respiratory and neurological issues, anything else?
No, I don't believe so.
Is that right, Ms. Knight?
That's my understanding, yes.
All right, so you can have any medical records relating to respiratory issues or neurological issues from 5 years prior to the first exposure through today involving the plaintiff. So, and then of course, anything that they're claiming in this case. So any respiratory so if she had he or she had a broken leg, that's not going to be relevant. If there's some gynecological issues, that's not going to be relevant and not discoverable. But if it's respiratory or neurological, then you can get those. All right, what's the next is Social Security. I'm not sure why you need Social Security records.
Yeah, Your Honor, our response to that is that was no benefits were ever brought up either in
Did she
the
get
deposition. Yeah, that they.
Did she get disability through Social Security or?
No, she did not.
All right, I'm not going to allow Social Security. For lost wages, what I typically do is allow W-2s or any other. If this is a person a wage earner, or do they own their own company?
So both. She actually lost the business that she founded as a result. We provided the K-1s. As far as they're requesting tax returns all the way from 2014 when this started happening in 2018. So
I would, in that situation, I would usually do W-2s and 1099s, or I guess K-1s from 3 years prior to the first exposure to today, to provide some kind of earning histories. But you don't need to provide the entire tax returns, and any passive investment does not need to be produced. So if she had a mutual fund or whatever, that's not going to be produced.
and the last one was an employment authorization. It was just an extremely broad authorization that didn't really address anything. It just asked for all personnel records, payroll records, training records, duty assignments, other documentation. There's no start date, end date, expiration date.
You said she lost her business. Did she also lose her job?
No, but she is claiming lost wages from her job that she was working at the time, but she did lose her business.
She's also claiming that she had to change her hours, come in at different times, was not able to work as much. That her tasks that she had to perform while at work were altered because of it. She was not doing as well, not making as much. There were a lot of things that were mentioned about her performance at work due to the injuries that she suffered.
She works on her feet. Your Honor, she's a bartender, so I think.
So this is a little more complicated, obviously. So did she have just one job throughout? Is that kind of how this worked?
No, so she had her bartending job, and then she also had a meal prep company that she had started, and that she had to actually shut down because of her health issues.
Okay.
My
Response on
My understanding is that it was not also just a bartending job. It was more of a bottle service. There was more to it than just bartending. She wasn't just showing up and making drinks. She was promoting. There were activities involved. It was more than that.
I may not be an expert on this, Ms. Knight. What is the difference between bottle service and being a bartender? I don't know the difference.
I'm trying to pull it up. Right.
Is bottle service like they bring bottles to the table or something?
So my understanding is that she was doing more than just making drinks behind a bar. That she was taking orders, she was going back and forth to the table, she was entertaining, she was seating people, she was doing more of hostess activities than just in management.
Where did she work again? What was the name of the place? it doesn't matter, I guess. I mean, what I would suggest in this situation is that, because it's going to be really hard to figure out there's no black and white here, but is have the employment records go to Ms. Hamida. If there's anything you want to withhold out of the employment record, so anything from 1 year prior to the accident to today would be produced to you. You try to, if there's anything you want to exclude, have it submitted to me in camera to take a look at. Because I could see, for example, let's say she was accused of sexual harassment, for example, and that's come up a number of times in cases, believe it or not, or she made a claim of sexual harassment, either way, or employment discrimination or whatever, that's not going to be relevant to this case. And so I don't want us to go into that, or if she had, some personal issues or whatever, that's not going to be relevant. And so if there's something but typically if things that talk about what she does physically on the job, how those limitations were documented and things like that, that would be relevant. And so, but I can't really tell I don't know what's in the employment records, and I don't fully think I understand what her job was exactly. So does that make sense, Ms. Hamida?
Yes, Your Honor.
So go ahead, and when you prepare the order on this, Ms. Knight, go ahead and include that those records are going to go directly to Ms. Hamida for 1 year prior to the exposure to today. And then she'll make a determination if anything needs to be withheld, and then there'll be an in-camera inspection at that point. Is there anything else?
I just want to clarify on the medical authorizations. You said any claimed injury, and right now we agree that it's just the respiratory and neuro injuries, but anything other than that, usually you do 5 years prior to the present.
It's 5 years prior related to the areas of the body that are affected. It's not everything. So any respiratory or neurological treatment 5 years prior to the incident to today, and anything related to the accident will be produced.
So
And she also suffered from, I believe, dermatology related, like she developed cysts. So
anything on that as well, then before you guys had said just those two, but if it's anything related to, if you're claiming it in this accident, or this, I'm sorry, not, well, I guess it is kind of an accident, but claiming it in this case, that it would be 5 years prior to treatment for that. So if there's dermatological issues, then it would be 5 years prior to the incident to today. And so you might want to go through the medicals to make sure what exactly should be included, because mold cases, I used to do these actually occasionally when I was in private practice, and I've handled a few of them on the bench. The medicals can get kind of complicated to say the least, because it is hard to tell sometimes what's related and what's not. And so, but if you're claiming it, then they get 5 years prior to take a look at it.
all right, thank you so much.
But if it's not related, you don't get any of it.
Understand.
No broken legs, no gynecological issues, no, unless they're claiming it in this case. All right, is that everything?
It is. Thank you.
I believe so.
So Ms. Knight, I want you to prepare an order for me on all this. The order will at the beginning say, instead of on this date, I wanted to say on February 28, 2022. I'd like you to prepare the order, share it with Ms. Hamida. Ms. Hamida, you'll have up to 3 hours, worked hours to respond. And then if you don't have any objections, then go ahead and sign off on it. And then Ms. Knight, you can submit that to the court, email my court coordinator, as well as e-filing it. And I'd like that by no later than Thursday.
Yes, Your Honor.
And I only say that because I've lately been getting orders like 2 months after the hearing. So I've started setting a deadline. So believe it or not, I'm like, I don't remember a hearing from 2 months ago. So it's better to do it when I'm fresh. So, all right, guys, thank you so much. And you guys have a good day. You be safe, okay?
Thank
You
you.
too. Thank you.
Thank you. Mr. White, Mr. Dunham, are you there?
Yes, Your Honor.
I'm sorry, I mispronounced your name. Is it Mr. Dunman?
Yes, Your Honor, Dunman. I get that off.
Apologize about that. Are we waiting on anybody?
not to my knowledge.
Is this on the motion to seal?
Correct.
Are you new counsel in this case, Mr. Dunman?
No, Your Honor, I am part of the law firm Reed Smith LLP with Elizabeth and Amanda, and I recently filed my notice of appearance so that I could handle the hearing today.
Okay. Let's go to the record on cause number DC 21-16103, BioT Medical versus Michael Antonelli. Counsel, make your appearances.
This is Clifford Dunman appearing on behalf of Plaintiff BioT Medical LLC.
This is Sean White appearing on behalf of defendants Michael Antonelli and DNA Health LLC.
Let's proceed.
Yes, Your Honor, we're seeking a motion for a permanent seal on two exhibits that were two documents that were exhibits to this court's temporary injunction order. The first one being Exhibit B to the temporary injunction order, which contains a list of BioT's customers and clients, as well as Exhibit C to that temporary injunction order, which was an asset purchase agreement between defendants and certain other entities that contains certain contract and pricing terms. And both of these documents that contain proprietary and trade secret information and those.
Before you get too far down the road, I just want to say that we've been informed by the clerk's office that they can't seal individual documents. They can seal individual filings. So if this was filed as part of another document, they can't seal part of the document and not the whole thing. So just FYI, when you're doing this, just realize that we can't just seal part of a document.
Understood, Your Honor.
Or part of a filing is what I mean.
Sure. So as far as the statutory requirements, the parties' interest in protecting the privacy of this information.
Is this, remind me again, is this a 76A permanent sealing or temporary sealing order?
This is a permanent sealing order. We obtained a temporary sealing order from the court a couple of weeks ago.
Did you post this?
Yes, Your Honor. We posted a public notice posting. We received an issuance from Dallas County District Clerk's office, and I executed the public notice posting. And this was
Did the notice say when the hearing was going to be?
Yes, Your Honor.
And indicate that the hearing was going to be on Zoom, or did it say it was going to be on person?
It said that it was by live video and telephonic appearances only.
Wow. Say that again.
The public notice posting for motion to seal states that the motion to seal exhibits will be heard on February 28th, 2022 at 2:30 in the 68th Judicial District Court by live video and telephonic appearances only.
Live video and telephonic appearances only. I'm not sure I understand what live video is. That like Zoom, or what does that mean?
In my understanding, yes, Your Honor, that it would be whatever Zoom or the court, the docket websites live, live video interface for the court.
Mr. White, do you have any problem with that language, or are you okay with it?
No, Your Honor, I'm fine with that. I think it's just trying to signal that it's not going to be an in-person hearing in your chambers.
No, it's just the wording's a little confusing. What I'm going to do right now is I'm just so it's clear for the record, and this is also on YouTube so that the public can see this, and it's being live streamed so the public can see this. But because I'm not 100% clear what that means, I'm going to call my court right now. I'm actually at my house. I'm going to call the court and instruct the bailiff to go check the halls to make sure there's nobody here that wants to appear. If they do, then we're going to sign them onto Zoom. So give me 1 second.
Sure.
I know that's, you probably are thinking to yourself, I'm overdoing it, but I've actually had members of the public show up to these things before. It just never know. So. Rhonda, I'm on the record right now, and Tony, we need to be on the record for this.
Okay, I'm logging back in.
Well, okay, why don't you come on the screen real quick?
Okay, hold on.
Thanks. So what I'm going to do is have my court coordinator tell my bailiff, who I think is there, I believe. If he's not, then she will. I'll have them call the halls to make sure that nobody showed up at the courthouse, just to cover all our bases. And while we're doing that, Mr. White, are you opposing this?
No, Your Honor.
Okay. So, and when you do the order, it needs to detail which filings exactly. So if, for example, this exhibit was attached to a summary judgment or something, that whole summary judgment needs to be sealed, and you need to identify within the order what exact documents are going to be sealed. Does that make sense?
Yes, Your Honor.
Because we've had this issue before. It may not seem like a big deal, but I've had serious problems with the clerk's office, and I don't employ the clerk, so I can't fix this, unfortunately, but they refused or I've been unable to seal certain things or identify certain things. And so Ms. Pinson, on the record, is my court coordinator. Can you hear me okay? Can you turn on your, Rhonda, you're going to be on the record for this. Can you go get our bailiff? Is Sheriff Avon in today? I can't hear you. Oh,
Yes, he's in today. I'll go get him right now.
okay, can you get him real quick? Does that make sense, Mr. Dunman, on how to do the order?
Yes, Your Honor. So just to confirm, just identify the filing overall that is to be sealed and
The date of the filing, so like the summary judgment filed by defendant hypothetically on, December 2nd, 2022 shall be sealed. So identify it like that. So you want to make it as clear to the clerks. And then once the clerks get the order, I would double check it to, a week or so after I sign it, and make sure that it actually is sealed. And if it's not, then call my office and say, hey, look, they haven't sealed it, so that I can call them and make sure it gets sealed, because I wish there was a more efficient way. I wish I had control over this, but I don't. So I only can, they'll follow the order. It's not like they're disobeying. You just have to make sure that they do it.
sure.
Hopefully she'll get back in a second. Anyway, go ahead and finish up whatever else you need to say.
Yes, Your Honor. Yeah, and obviously I agree that you can never be too careful when civic duty and civil rights come into play. So as far as the statutory standard for receiving a sealed order, the sealing of this motion will hamper the public's ability or the public's interest in openness of the filing.
Is he here, Rhonda?
He's on his way now.
Okay, he needs to get on the screen whenever he gets there.
Okay. He's coming down the hallway now.
Can you give him he's going to need the case name. This is the BioT case. He'll need to call the halls. All right. Deputy Avon, can you hear me okay?
Yes, sir, I can.
All right. So we are in the middle of a 76A motion, which requires that the public can participate in this motion if they'd like. We posted a notice that it's a little unclear that whether or not somebody, if they were interested in showing up, would show up in person or remote. And so in an abundance of caution, I'd like you to call the halls and see if there's anyone here on the BioT case. And Ms. Pinson, if you could give the information to Deputy Avon about so that he'll know what case to call. So just call the halls. If there's anyone here on that case, Mr. Deputy Avon, if you could bring them back to Rhonda's office and have them get on the Zoom.
Yes, sir.
Thank you. And then come back if there's nobody there too, and let us know.
I will.
Thank you. And Rhonda, I want to make sure that did anybody contact the court asking for a Zoom link to be able to participate in this hearing other than the attorneys?
No.
Okay. All right, go ahead, Mr. Dunman.
Thank you, Your Honor. The proprietary interest in the information contained in the documents constitute a specific and serious and substantial interest for the parties, which outweighs the public's presumption of openness for the filings, as well as any potential adverse effect that the seal would have on the general public health or safety. As well, there are no less restrictive means than sealing the records that will adequately and effectively protect the specific interests asserted.
Okay, anything else?
Oh, I'm sorry.
Go ahead, Deputy Avon.
Sir, I called the hallway and nobody is here on that case.
Thank you, Deputy. Mr. White, Mr. Dunman, before he leaves, anything else you'd like the court staff to do in terms of notice? Mr. Dunman?
No, Your Honor.
Mr. White?
Not for me, Your Honor. Thank you.
Thank you, Deputy Avon.
More than welcome. Thank you, guys.
Okay. Anything else, Mr. Dunman?
No, Your Honor. That's it for plaintiffs.
Mr. White?
No, I'll just concur that this is proprietary trade secret information of both plaintiff and defendant. That, as Mr. Dunman said, doesn't have any health or safety implications for the public. It is business related trade secret information. So we concur that it ought to be permanently sealed.
Okay. The court will go ahead and seal it. I just want to stress that because we've had this issue come up, we're not sealing the entire case. We're just sealing any filings that have these particular documents that are proprietary. So I've had a couple of times where attorneys come in and say, we want to seal the entire case, but only filings, and this would not include orders. We can't seal an order, but any filings that include the proprietary information detail need to be specifically listed within the order and make sure that make sure that's detailed in the order. Also, at the beginning of the order, if I haven't said this already, it should say on February 28th, 2022, as opposed to on this day. If you could get the order to email the order to Mr. White to make sure that he doesn't have any issues with it. And Mr. White, you'll have 3 hours to make any comments and then 3 work hours. So if he sends it to you at midnight, you'll have 3 work hours. And then get it to Rhonda no later than Thursday of this week.
Yes, sure.
And the sooner the better, because I'd like to sign it sooner than that if I can.
Yes, Your Honor.
And Judge, I'm sorry. I have a question for me for the transcript purposes.
Mm-hmm.
If I'm not mistaken, it was a lot of exhibits submitted at the TI hearing. And I don't know if that encompasses those 2 exhibits or not. For me, transcript purposes, what should I do?
Mr. Dunman?
There were certain exhibits entered that did contain confidential information. And correct me if I'm wrong. So if the order seals this particular filing, would that also seal any of the exhibits that were entered in there?
That's an interesting point. Usually people don't bring that up, but if they do, what I've always assumed is that you would need to detail that in the order. The only way this really comes up is if this goes on appeal, and then she would have to produce it to the Court of Appeals, kind of in that brown envelope, or a special filing. But it doesn't usually come up. But if you guys make sure that you let Tony know if there's something she needs to do special. Okay.
Well, it
Anything
is
else,
on appeal. It is on appeal. Mr. White appealed it, so.
It is, Your Honor. Yeah, so this is an issue.
So yeah, make sure that the order so reflects and that Ms. Rieger has a copy and instructions on what to do. Okay. Anything else, guys?
No, Your Honor.
You guys be safe, and we'll see you on the next one, okay? We have another hearing that's supposed to start at 2:45, Tony, so don't leave. Is that canceled?
They canceled.
So I can't pull up Odyssey right now, so what the next one I have, you guys are welcome to head out. Mr. White, Mr. Dunn, thank you so much.
Thank you.
Is the 3 o'clock still on?
Yes, we're still live.
Okay. All right, so go ahead and sign on at 3 o'clock. Tony and Ayana and Rhonda, we probably won't need you, so just go ahead and take care of your stuff. And I guess you guys saw the order that the mask mandate at the courthouse has been lifted. So